All right, I haven't done one of these in a while. It's Thursday morning, December, 18th or something. I don't even know anymore what the date is. I'm going to go through a court order that we got from a judge about a week ago in the Kilmar Abrego Garcia case. This was the order written by Judge Paula Xinis, I think is how you say her last name, spelled Xinis. She's a United States District Judge for the District of Maryland, which means that she's at the trial court level. So she hears evidence and she oversees trials and she hears motions and things like that. And so this was the order that came out last week, ordering that the government and ICE release Kilmar Abrego Garcia from detention. And she ordered him to be released immediately, stating that the government had no legal basis to detain him at all. And this is an important order for a couple of reasons. She goes through, so anytime you have a court order like this, that's a result of a motion that is filed by one party. And he had filed a motion, a writ of habeas corpus, which is Latin for release the body. So he had filed a motion asking the court to order that he be released from ICE custody. So this is the order that is resulting from a hearing that took place on that motion. And the structure of how these kinds of orders are written is there'll be an opening paragraph saying, this is what this order addresses. This person filed this motion. We had a hearing. This is the order resulting from that hearing. And then there will be a kind of a factual background section, basically just kind of laying the factual foundation for the decision that the judge reaches. Because when trial court judges decide these kinds of motions, they listen to the facts, they determine what the facts are based on testimony and documents, and then they determine what law is applicable, and they apply the law to the facts, and then they get to their conclusion. So it's intro, facts, legal analysis, and conclusion and order. The important thing about this motion to me is the factual background section. She doesn't sugarcoat how the government has treated Mr. Garcia in this case over the since last March. She states explicitly that attorneys representing the government lied to her in open court and in documents, and she points that out. They lied. It's quite amazing. But the factual background history of this case. So remember that Kilmar Abrego Garcia was detained by ICE in the second week of March. And then he was put on one of those planes that was sent to El Salvador. And he was sent to Secot prison, where he stayed for 4 months, along with, it was around 260 young men, 90% of whom had never been convicted of a crime. The Trump administration said every one of these young men is a member of the violent Venezuelan street gang Tren de Aragua. It turned out none of them were. All of them were denied due process. Mr. Garcia filed a motion based on due process to get released from Secot prison. The trial court ordered him to be brought back to the United States. That order was affirmed by the appellate court, and it was affirmed 9-0 by this Supreme Court that his due process rights had been violated. So ICE the government brought him back, and then immediately indicted him on human trafficking charges, and they put out an egregious indictment against him, saying that he was a drug trafficker, a drug smuggler, a drug runner, was dealing drugs, was engaged in all kinds of human trafficking, was a gang member, an MS-13 member, and that he had solicited videos and photos from a minor that contained nudity and sexual content and all of that stuff, but they only indicted him for one count of human trafficking. And so the indictment itself was retaliatory because he had sued the Trump administration for various things. And so when ICE brought him back when the government brought him back to the United States 4 months after they sent him to Secot prison this past March, they immediately detained him again, and they have kept him in detention since his return to the United States. He filed a motion arguing that they have no legal basis to detain him, and that's what this order addresses. So it starts out with the intro saying, Kilmar Abrego Garcia petitions this court for a writ of habeas corpus to release him from the custody of respondents. So respondents are Department of Homeland Security, ICE, Noem. Since Mr. Abrego Garcia's return from wrongful detention in El Salvador, he has been re-detained again without legal authority. So the court is telling you right out of the gate how they're going to decide this motion. They detained him again without legal authority. The judge is saying that ICE, DHS has no legal authority to detain him. For this reason, the court will grant Mr. Garcia's petition for immediate release from ICE custody. That's the intro. That tells you what we're looking at here. Then we get into the background section. And this, how the government has treated this guy simply because he stood up for his rights, is how they are going to treat all of us eventually for standing up for our rights. So that's why this decision and opinion are important. Background: the history of Mr. Garcia's case is as well known as it is extraordinary. The court will not recite all of it here, but only those events necessary to explain why Mr. Garcia is entitled to immediate release. Now, here's some important background information for everybody here, just so you can get a feeling for what his case has been. He is a national of El Salvador. At 16 years old in 2012, he came to the United States as a non-citizen to avoid persecution by the notorious gang Barrio 18 in El Salvador. For many years thereafter, he lived and worked in Maryland. But in 2019, after a brief encounter with local police, ICE took custody of Mr. Garcia and commenced removal proceedings to El Salvador. So that's 5 years ago. So he's been in the system for a while. And now we get to learn more about what that looked like. Mr. Garcia, in turn, asked an immigration judge for 3 kinds of relief from removal, meaning he filed a motion saying, please don't send me back to El Salvador for the following reasons. Withholding of removal order under the Convention Against Torture, meaning if you send me back there, I'm going to be tortured. And then there were 2 other statutory factors. The immigration judge said that he hadn't satisfied the second and third bases that he raised, but he did satisfy the first one. Let's see here. After an evidentiary hearing in which Mr. Garcia testified and was found to be credible, the immigration judge granted him the ability to stay in the United States and denied the remaining requests. So this becomes important later on in this motion because the immigration judge issued an order. The government says that order means one thing, and Mr. Garcia, and the court agrees with him, says that order means a different thing. The immigration judge memorialized this determination in a written memorandum and decision of order dated October 10th, 2019. The October 10th withholding decision referenced as procedural history Mr. Garcia's concession at a prior hearing that he was an El Salvadoran national who entered the United States without lawful permission, and that an immigration judge found his removability to be established by clear and convincing evidence, meaning the government met its burden in saying he's not here legally, he needs to be removed. The immigration judge said that the government met that threshold, but he contested that under the Convention Against Torture, and the judge said that's an exception, you're credible on this and you get to stay here. But nothing suggests that the immigration judge actually ordered Mr. Garcia to be removed to El Salvador. It held the exact opposite. The withholding decision included a separate order that did not command Abrego Garcia's removal to El Salvador or removal to anywhere else. And that becomes important here because the government this year has tried to remove him or deport him to 4 separate countries in Africa where he's never been before, and lied to the court about a lot of that stuff. And that's where it gets kind of juicy. For the next 6 years, Abrego Garcia lived and worked in Maryland subject to an ICE order of supervision. So he had to check in with ICE periodically, but was allowed to stay here and had a court order saying he was allowed to stay here. But on March 12th, 2025, while driving with his son in the car, ICE agents pulled over Mr. Garcia and arrested him. 3 days later, respondents, government, DHS, forcibly expelled him along with 252 Venezuelan and Salvadoran nationals to El Salvador, where they were detained in Secot prison. While at Secot, the men, including Mr. Garcia, were systematically beaten and tortured. In response, on March 24th, 2025, so about 10 days after he was sent to Secot, Mr. Garcia filed a lawsuit with this court and separately moved for an injunction directing respondents to secure his immediate release from Secot and his return to the United States. On April 4th, so less than a month after he was taken there, the court granted such relief, ordering the government to facilitate and effectuate his return to the United States. Respondents appealed, and within days, the United States Court of Appeals for the Fourth Circuit and the Supreme Court affirmed the lower court's order and modified to command facilitation of Abrego Garcia's return, quote, to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. In the ensuing weeks, respondents refused to return Mr. Garcia to the United States. 2 months later, on June 6th, he was returned to the United States, but only after the government secured a federal indictment in Tennessee against Mr. Garcia for the human trafficking charge, a matter that is itself under scrutiny for vindictive and selective prosecution. That indictment's going to get thrown out because it's vindictive and selective targeted prosecution for vengeance, basically. Once in criminal custody and after several hearings, Abrego Garcia was released on stringent conditions of supervision. But the government found this result intolerable and complained bitterly. The government also warned Mr. Garcia that upon his release, ICE would take him back into custody to effectuate his removal to a country other than El Salvador. Mr. Garcia, in response, urged the court to order his return to Maryland under ICE supervision terms that were in effect prior to his wrongful detention and removal in March. The court also ordered that in the event that the government initiated third country removal proceedings, meaning sending him to a third country that is not El Salvador, that they must give Mr. Garcia 72 hours notice of the intended third country. Meanwhile, during plea negotiations in the criminal case, the country of Costa Rica offered to grant Mr. Garcia residency as a refugee. The country of Costa Rica voluntarily offered to give him refugee status and let him come to Costa Rica. That was not acceptable to the government because that was a place where Mr. Garcia was willing to go. They were only willing to deport him to a country where he was not willing to go. and there's confirmation of all of that. The next day, on August 22nd, as Mr. Garcia left the detention center in Tennessee, respondents served him with a notice to appear at the Baltimore ICE field office the following Monday. Respondents separately notified his attorney that they intended to remove Mr. Garcia to Uganda in Africa. Mr. Garcia immediately responded with written notice to the government of his fear that if he is sent to Uganda, he would face persecution, torture, and ultimately be sent back to El Salvador. He separately notified the government in writing that Costa Rica is willing to accept him, and that's where he will go. He will go to Costa Rica immediately if the government will send him to Costa Rica. He'll go there immediately. Mr. Garcia next appeared at the ICE office in Baltimore on August 25th. He was immediately taken into custody, and according to DHS Secretary Kristi Noem, he was being processed for removal to Uganda instead of Costa Rica. Because it's vengeance. It's vengeance. They want to send him to a country on a continent that he's never been, to a country that he's never visited, where he doesn't speak the language, where he has no family support network, he has no friends, and a country where the government is likely to detain him and mistreat him or torture him. That's our DHS right now. Mr. Garcia, in turn, filed a petition to prevent that from happening. The petition also challenged the constitutionality of Mr. Garcia's continued detention because there was no valid order of removal, meaning the government had never gone to court to get an order removing him from the United States. They've not gone, and that's under the terms of the Immigration Naturalization Act. If the government's going to deport you, they have to get a court order saying that they have the authority and the go-ahead from a court to deport you. The court set a briefing schedule on the petition, and an evidentiary hearing took place on October 6th. In the days that followed, so before that hearing, the government took no steps to process Garcia for removal to Uganda, ostensibly because of his claimed fear of persecution and torture in that country. Instead, on September 5th, the government notified Garcia's counsel that they would now remove him to the South African country of Eswatini instead of Uganda. Abrego Garcia immediately asserted fear of removal to Eswatini for similar grounds. Within days, the government of Eswatini learned of the government's notice to Mr. Garcia, and it bit back. On September 11th, a spokesperson for the country of Eswatini, Thabile Meduli, announced that, quote, the government of Eswatini had not received any communication regarding this person and did not have any agreement with the United States to receive Mr. Garcia. Respondents had not done anything with Mr. Garcia's credible fears, assertions communicated about torture, things like that. However, having heard nothing, and with the October 6th hearing approaching, Mr. Garcia asked the court to order targeted discovery on the respondents' plans to remove him to either Uganda or Eswatini in lieu of Costa Rica. It's just fucking comical. If it weren't so fucking evil, these people are just evil, but they are also unimaginably inept and incompetent. Thankfully. And the court said, yeah, you can do discovery against the government about Eswatini and Uganda. The court converted the October 6th evidentiary hearing to a status conference. And so an evidentiary hearing is where each side is calling witnesses and there's testimony and you're introducing documents into evidence. An in-person status conference is just an informal conference with the judge, where the judge is asking questions to the attorneys raise concerns, they're all talking to each other, It's a much more informal proceeding. At the status conference on October 6th, the court tried to assess whether the government had made any real effort toward removing Mr. Garcia. It quickly became clear that they had not. The government, through counsel, could say no more than Eswatini had been selected for Mr. Garcia's removal, but they had no information about whether the government had even asked the country of Eswatini about this. Nor did the government have any further details about whether any efforts had been made to secure Mr. Garcia's removal to Costa Rica, which said they would take him, and he said, "I will go to Costa Rica." This was so even though Mr. Garcia reaffirmed that he would depart, quote, "this afternoon," close quote, for Costa Rica, thus obviating the need for any further hearings or adjudication of this petition. Counsel for Mr. Garcia stated, if the government's goal is to effectuate removal, he would be in Costa Rica right now, because their goal was not removal. Their goal was punishment. Their goal was punishment, retribution, and the infliction of pain, both physical, mental, and emotional, because he stood up to the government, because Kilmar Abrego Garcia stood up to the government, and he was winning, and that pissed off Trump and Kristi Noem and Tom Homan. Because respondents had done nothing other than send emails to Garcia's lawyers about Uganda and Eswatini, Mr. Garcia asked the court rule expeditiously that he be released. Government, in turn, asked for an evidentiary hearing to demonstrate the sincerity of their third country removal efforts. So the government asked for a hearing on that. The court granted their request and specifically ordered the government to produce a witness or witnesses to testify about what steps, if any, the government has taken to remove Mr. Garcia to Eswatini or any other country, including but not limited to Costa Rica, and what additional steps, if any, the government will take in the reasonably foreseeable future to remove Mr. Garcia from the United States. The court held an evidentiary hearing 4 days later on October 10th. The government produced one witness, Deputy Assistant Director of ICE Enforcement and Removal Operations, John Schultz. Contrary to the court's order, Mr. Schultz was not prepared at all to discuss Costa Rica, their offer to accept Mr. Garcia. Mr. Schultz candidly admitted that he had not seen Costa Rica's August correspondence and that he had no knowledge about whether the government had done anything to commence removal proceedings to Costa Rica. So the government asked for a hearing on this issue. They asked for it. And the judge said, I'll give you the hearing. I'm ordering you to produce someone who is knowledgeable about these issues and who can testify in depth. And they produced a guy who didn't know anything about any of this. Next, as to Uganda, Mr. Schultz testified that the government had asked Uganda to take Mr. Garcia, and Uganda said no. Eswatini also said no. Mr. Schultz confirmed that the night before the hearing, the government notified Abrego Garcia that they are now going to be removing him to a third African country, the country of Ghana. But once this purported designation to Ghana became public, the foreign minister of Ghana, Sam Okudezeto Ablakwa, immediately announced that Ghana was not accepting Mr. Garcia. He cannot be deported to Ghana, and that this petition has been directly and unambiguously, this position has been directly and unambiguously conveyed to U.S. authorities. So this is the third time where they've said we're sending him to this country in Africa. That country finds out about it and says, no, you're not. This is the third time that's happened. Uganda, Eswatini, Ghana. All three of them said, no, we're not taking him. And the government never asked them ahead of time. Mr. Schultz ultimately confirmed that he knew of no impediment to remove Mr. Garcia to Costa Rica and doesn't understand why that hasn't happened. Mr. Schultz further attested that he had been told nothing about why the government had not yet processed Mr. Garcia's removal to Costa Rica. Counsel for Mr. Garcia in turn emphasized that his client's continued detention must be for purposes other than facilitating removal. That's the part that's illegal because they're detaining him for punishment. Not allowed to do that with immigrants. Because if respondents wanted to remove him to Costa Rica, they can put him on the next plane to Costa Rica. Indeed, in oral argument, the government's attorney acknowledged that the only legitimate ground to hold Mr. Garcia was to effectuate removal. And so now we're almost 2 months past the date that Costa Rica said we will accept him, and Mr. Garcia said, I will go there, and the government still hasn't removed him because they keep trying to send him to places in Africa. And yet the government's attorneys had no answers as to why the policymakers refused to send him to Costa Rica. The best they could do was stipulate that Costa Rica is on the table if Eswatini falls through. Eswatini had already fallen through. The court concluded the hearing. Hang with me, we're getting to the lying part here in a minute. The court concluded the hearing, said that it would rule expeditiously, but before the court could formally rule, the government notified Mr. Garcia and the court on October 25th that now they intended to remove him to a fourth African country, Liberia. Liberia evidently agreed to accept Mr. Garcia on a strictly humanitarian and temporary basis with promises not to persecute or torture him. So limited basis, which means that they were going to send him back to El Salvador, where he would definitely be tortured. The court convened a status conference after the Liberia notice, during which Abrego Garcia requested one final hearing to address the remaining counts of his petition. And the court allowed supplemental briefing and set a hearing for the following month. In their subsequent filings, the government justified removing Mr. Garcia to Liberia because it was the only state willing to accept him. The government told the court that Costa Rica does not wish to receive Mr. Garcia any longer and that Costa Rica would not accept Mr. Garcia. Thus, said the government, that the government can hardly be at fault for not removing Mr. Garcia to a country that refuses to accept him. All of that was lies. All of that was lies. Government also attached the sworn declaration of ICE Acting Assistant Director for the Removal Division, Jonathan Cantu, as purported evidence of Costa Rica's change of heart. So they attached a sworn affidavit from this guy, Jonathan Cantu, who is the ICE Acting Assistant Director for the Removal Division, a sworn statement under penalty of perjury from him saying Costa Rica changed its mind and they're not willing to accept him any longer. They didn't attach to that declaration any letter or documentation from Costa Rica saying that. It's just a declaration. It's a trust me bro declaration. Oddly, however, the government submitted their memoranda in the Cantu declaration under seal and moved to seal the evidentiary hearing entirely. That's because with Uganda, Eswatini, and Ghana, those pleadings were filed publicly, and those pleadings got out into the news. And when those pleadings got out into the news, all three of those countries said, we're not taking him. So now that they want to remove him to Liberia, now they want everything under sealed and out of the public eye, because they're saying Costa Rica said we won't take him, Liberia said they'll take him, and they don't want that information getting out public because Costa Rica was still agreeing to take him and Liberia was not. Respondents also did not attach any communication from Costa Rica reflecting any rescission or modification of its prior offer to receive Mr. Garcia as a refugee. Mr. Garcia quickly asked the court to make Mr. Cantu available for testimony. The court granted that motion over the government's vigorous objection. I wonder if the government just made up this declaration and put this guy's signature on it without him actually knowing anything about it. Falsifying evidence. The court also unsealed the relevant filings and ordered the government and their lawyers to prepare the witnesses in good faith to answer questions about Costa Rica's willingness to accept Mr. Garcia. At the hearing on November 20th, it became evident once again the government had defied this court's orders. They simply refused to prepare and produce a witness with knowledge to testify in any meaningful way. Mr. Cantu candidly admitted, for example, that he had no prior involvement in Mr. Garcia's case and spent approximately 5 minutes preparing to testify. Mr. Cantu also shared that none of the government's attorneys had discussed this court order with him or showed him its contents, nor did Mr. Cantu understand the purpose of his testimony. Amazing. Ultimately, the government's calculated effort to take Costa Rica off the table backfired. Within 24 hours, Costa Rica communicated to multiple news sources that its offer to grant Mr. Garcia residence and refugee status is, and always has been, firm, unwavering, and unconditional. It never changed. The government lied to the court in writing and in oral testimony, in the statements that the attorneys in the courtroom were making to the court. They falsified a declaration from an ICE official saying that Costa Rica is no longer willing to accept him. And when that government official had to take the witness stand and testify, he's like, I don't know what any of this is. I've never seen that before. The government attorneys falsified evidence and gave it to a federal judge and lied. It's incredible. It's absolutely incredible. It's absolutely incredible. And so that's the factual background of this. So then we get to the legal analysis. And despite this tortured history, Mr. Garcia's arguments in favor of release are quite simple. He contends that his detention is without lawful authority because the government has no final order of removal authorizing as much under the third country removal statute. Thus, says Mr. Garcia, his release is compelled. In order to hold him in detention, the government has to have a valid order of removal, meaning an order from a court judge saying that they are permitted to remove him from the United States. The government never got that order with regard to Mr. Garcia. They lied to the court and said they had one early on in the case, and then it became clear that they didn't. And then they tried Uganda, then they tried Eswatini, then they tried Ghana, then they tried Liberia, lied to the court about all of that, then lied to the court about Costa Rica, got busted. It's just absolutely stunning. And so it's not a difficult motion. In order to hold me in custody, the government has to have a valid order of removal, and they are only permitted to hold me for so long as it takes them to remove me to another country. And so these attorneys, and I mean, the way this government has treated, skipping ahead a bunch, the government instead found a fourth African country, Liberia. This time when the court sought information about Liberia and Costa Rica so as to fairly assess the validity of Mr. Garcia's claims, the government did not just stonewall. They affirmatively misled the tribunal. That's a fancy way of saying they lied to this judge on purpose. It's unimaginable to see a federal judge write something like that about an attorney representing the government of the United States employed by the Department of Justice. It is fucking unimaginable. It just doesn't happen. It just doesn't happen. But now under Donald Trump and Pam Bondi and Kristi Noem, it happens all the time. So that's the meat of the factual situation in this case. The judge did order that he be released immediately, and then ICE said that they were going to detain him again. And so at something like 7 a.m. last Sunday morning, the judge issued another order prohibiting ICE from detaining Mr. Garcia for any reason until the motions in his criminal trial are worked out. So ICE is not allowed to detain him at all. And so for the first time since last March 12th, Mr. Garcia has effectively spent the last week with his family, despite the best efforts of this petty, vindictive, stupid, incompetent, and malevolent and evil Trump administration. So hope you enjoyed that. If you did like that, please click like and subscribe. If you have questions or anything, please leave them in the comments. You know, I'll try to answer them later on. I hope everybody has an amazing Thursday. See you guys soon.